Hello everyone and welcome to the lecture series for the preparation of CLAT examination. In this particular lecture series, we are discussing about the important topics of your CLAT preparation, specifically focusing over the legal reasoning areas of your CLAT examination. As you already know that we have completed a lot of topics which is in regards to your preparation. We have completed the law of torts. We have completed your we have completed your Constitution of India also. We have completed with the Indian Contract Act and also the criminal laws. We have started with the family law and we've discussed the origin and the sources of family law in regards to the Hindus as well as the Muslims. In the previous video, I have informed you that how you are supposed to prepare for your examination and what are the key important factors that one should keep in mind whenever they are preparing for CLAT examinations. We have discussed that it is important, it is pertinent to continuously and consistently practice over the problems that you see in your mock test and in your previous year question papers in regards to your CLAT examinations. Why am I informing you this? Because as I've informed you in our previous video that when you prepare for CLAT examination, it is not actually relevant that to what extent you are in depth studying the subject, but rather how you are providing the output. That is perhaps much more important. So when we talk about CLAT examination as such, we've just informed you that 150 questions and 120 minutes. It specifically means 33 seconds for one particular question. So your speed of reading and understanding and analyzing the topics should be very fast. It should be very quick. And for that, we need consistent practice. So with the hope and with the recommendation that every CLAT aspirants, whomsoever are preparing for that examination, should focus on continuously and consistently revising the principles and then practicing and maintaining the persistency. It will be easier for all the CLAT aspirants who actually wish to clear the examination to pass with flying colors. With this, I would like to inform you that in our previous video, we have discussed about the Hindu Succession Act. Let's come back to the topic and let's discuss why we have gathered it. In the previous video, the Hindu Succession Act of 1956, arrangement of sections, we have actually discussed about the two types of successions. One being the testamentary succession and one being the intestate succession. In the testamentary succession, we talked about the will that if at all a person who has died before his death, he has provided a piece of document which is registered, which talks about how the property after the demise of the rightful owner of that property will be devolved to the people who has been given the rightful ownership in that particular will. Section 31 of the Hindu Succession Act of 1956 actually describes that what exactly is testamentary succession, and that is also what we have discussed in our previous lecture. In today's lecture, we are going to discuss about the intestate succession. That is that type of succession where which a person has died, leaving behind no will as such. So if the person who has died has left no will, then the property will be divided and among the rightful heirs according to the Hindu Succession Act of 1956. So in this particular lecture, we are going to discuss what exactly is intestate succession. What exactly is intestate succession according to the Hindu Succession Act of 1956. Let's start with the lecture. As you can see on the screen, the first and the foremost chapter of the Hindu Succession Act talks about the preliminary things that we have already studied under the Hindu Marriage Act of 1955. We have studied about the short title and the extent. We have studied about the application of the act. We will study what exactly are the definitions and the interpretations and overriding effect of the act that we have already studied under the Hindu Marriage Act. So I will not be repeating those topics again. If you are not able to understand that how the application of the act and overriding effect of the act will be there, You can refer to that video with which we have discussed the Hindu Marriage Act in detail when we were discussing about the marriage between two Hindus. Two Hindus, if there has to be a marriage that needs to be solemnized, then what exactly is the process and the rules that is going to govern the marriages as such is also explaining that what exactly will be the application and what exactly will be the overriding effect. So application means to what extent the application, to whom it will be applicable. So in the same manner, it has been mentioned that the application will be for Hindus, and who exactly are the Hindus is also mentioned under the application of act under the Hindu Marriage Act. The same thing also has been mentioned under section 2 of the Hindu Succession Act, that it applies to Hindu, which does not include what? It does not include Muslim, Christian, Parsi, and Jews. So these four are included from the definition of Hindus. But what does it include? What does that include? It includes Jain, Buddhist, Sikh. These people are included, and any other person who follows Hindu custom. And other people are also mentioned, etc. or others, like if there has been mentioned under the Article 366 of the Constitution of India that these people are considered to be Hindus, then also it will be applicable to as the Hindus, but it is not applicable to the minorities. Okay. And then we'll be studying about act not to apply over certain properties. We'll discuss what type of properties are there on which this particular act will not be applicable. The evolution of interest in coparcenary properties. Now, what is coparcenary? Everything we is going to study in this particular lecture. This is not relevant for you. General rules of succession in case of males. This is perhaps very important, very important. And then we will study the order of succession among the heirs in the schedule. There is a schedule. There is a schedule. Let's see that schedule first so that you can understand what I'm referring to. It becomes perhaps easier for the candidate, for all the learners. Now, this is the schedule that has been referred. This is the schedule that has been referred. It says that there is a heirs in class 1 and class 2. Okay, heirs in class 1 and class 2, where which it is mentioned that is a class 1 hire. What does that mean? First, we'll try to understand it so that it becomes easier for you also to grasp what exactly we are referring to. So, what it means here, that there is a list of relatives, okay, people who are related to you, and if you die leaving behind no will, then the property will be divided in such a manner that there will be a class that will be formulated. That class, first class is called as class 1, and then there is another class which is known as class 2. And these are the heirs. Heirs means if a person X has died without leaving any will, then if there are three people who are related to X. Okay, let me do it in this manner. So there are three people who are related to X. One being the son, another being the daughter, and another being the wife. So if he has died leaving behind no will, then all property which belongs to X will now be devolved between the wife, the daughter, and the son. Why? From how we were able to know this? This schedule, the Hindu Succession Act schedule, provides the heirs in class 1, which says son, daughter, widow, mother, son of a predeceased son. Now, there is a son who has a son. Now, let's assume that this son has also died. X has died, son has died. But his son is present. His son is present. So, irrespective of him not being present because he has died, the property will be devolved. The property will now be transferred instead of the deceased person to the person who has survived the son. Who has survived the son in case the original property was of X? Son, daughter and wife were the three heirs of X. From that son, there was one more son. Okay, so this son had a wife also. For your better understanding, let's understand this, that this son had a wife also. And these two people, this son and the wife's son, they conjointly had one son. Okay, this is son. And by default, the property of X should have been devolved between his son, his daughter, and his wife. But it happens that this son is not present now. He has died. So the property, the share that this son would have got will now be transferred to his wife. One half of his property will go to his wife, and one half of his property, one half of the share of his property will go to his son. Okay. Let's try to understand in a better form so that everything is pretty much clear to you guys. This is one person X, okay, and he had 100 rupees, okay, and this is, let's take example, this is the cost of all his property, okay. So this is the cost of his property. This is just a hypothetical example for your better understanding so that you can understand how the property gets devolved. Now, X had one son, one daughter, and one wife. Okay. Now, if you talk about this 100 rupees, the cost of his property, these are the three people to whom this 100 rupees shall be divided into three equal shares. Okay. So wife will get 33%, 33.33. Son will get 33.33. And daughter will get 33.33% of the whole property. Now, is it clear to you guys? Now let's take the example again, and let's assume here that this son with whom we are talking to, who has received a share of 33.33%, dies before X. And he has been survived. He has been survived with two people, one being a daughter, okay, and another being his wife, okay. So this is X's son's wife, okay. And this is X's son's daughter. Now is it clear, guys? So these two people, since now he has died, but he has received a share of 33.33%. So these two people will get a share of 33.33% divided by two people. These are two people who have survived S, the son of the deceased person X, who has also died. So now if he is not alive, the property that has been there, that is his share. This is his share, okay. So this share will be again subdivided into these two people. So if we talk about X's property, W, his wife, will get 33.33% share, okay. Daughter of X will get how much? 33.33% share. Since son has died, X's son has died. So X's son, if he is not present, then obviously there will be no property that will be there. but he has been survived by his wife and a daughter. X, if he would have been alive, he would have also got 33.33% share. Yes. So that 33.33% will again be subdivided into these two people. If there would have been one more survivor of X's son, that is X's son's son, XSS. Here, if it would have been XSS also present, then this 33.33%, instead of being divided into two people, it would have been divided into three people. Okay. So this is how the property gets subdivided. The share gets subdivided. So that is in order to understand that what amount of share the person would be getting. But who will be getting and who will not be getting is something that we would have to understand, and that has been mentioned under these classes, which is being reflected in front of you. Class 1 higher provides the list of those relatives who are given priority, and once a person dies leaving behind no will, then these people will be given preference in regards to higher. The first preference will be given to son, daughter, widow, mother, son of a predeceased son, daughter of a predeceased son, son of a predeceased daughter, daughter of a predeceased daughter. Okay, so for this, what you need to do is, let's take this particular map. Okay, this is X. Okay, so to whom this property will be deviated, we'll try to understand for your better understanding. Okay, and once you understand this schedule, perhaps it will be very easier for you to understand the whole mechanism and how the things work. So first we'll try to understand what exactly the schedule is talking about. Okay, so if this person X dies, so he is saying that if he's been survived by anyone out of this particular list, if anyone or two or three or all are present, then they will get equal share of that property. Okay. Now let's understand what exactly I mean here. Now let's take example that there is a person X who has died without will. So his property will be devolved according to section 8. Section 8, which is talking about the transfer, the inheritance of property if a person, a male, dies without leaving any will. It says that if there is a son present, okay, if there is a son present, another, if there is a daughter present, okay, there is a daughter present, okay, and what else is there? There is a wife, okay, wife is there. Then you have mother. So this is the mother of X. Here we need to understand that in class 1 higher, we are talking about mother, but there is no reference of father. You will find father in class 2 highest. So mother will get the property of a son, but father is not supposed to get the property. This is obviously, sir, there is some lacuna, and you can cross question the judiciary once you happen to clear this examination, that why is it so that mother is given preference and father is given second preference after the mother. But there are certainly some reasons that you'll understand during your training when you prepare to become advocates and lawyers. Then at that point of time, you'll understand why is it so that the mother has been given first preference and the father has been given second preference. But for you as of now to understand that who will be considered as class 1 highest, we have mentioned that X has died. Now there is mother. There is a mother, M. M stands for mother. Then there is a wife. There is a wife. Okay. Then mother is there, son is there, daughter is there. These four are done. Son of a predeceased son. What does that predeceased mean? That son who has died during X life. So now take the example that when X was alive, his son died. His son died. But his son, before his death, had already married. So he had a wife and a son present. Okay. So he had a wife and son present. So that property shall be divided into son of a predeceased son. So this property will be going to him also. And this is son of a predeceased son and then daughter of a predeceased son. Now this son has died. He had one daughter also. So this and perhaps this also. Widow of a predeceased son. This is also mentioned. Widow of a predeceased son. So these three will also be getting the share. But these three will not be getting share equal to the mother and the wife. But rather, that share that the son will be receiving, that share will be devolving between these three people. Wife, daughter and son of a predeceased son. That is son, daughter and widow of a predeceased son. So if they have been survived. Now let's take an example that this daughter would have not been there. Okay. This daughter would have not been there. Then the property would have just been segregated between the son and the widow. Let's take the example that the son would have also not been there. Then the property of the son would have devolved directly to the widow. If we talk about in the same way, if the daughter is not present, what has been mentioned about the daughter? Son of daughter, daughter of a predeceased daughter. So now this is the daughter. He had a husband also. Okay. And this is the daughter. So daughter of a predeceased daughter, predeceased during the lifetime of X, the daughter died. But she left behind one daughter. This is the daughter of the predeceased daughter. This is the daughter of the predeceased daughter. Yes. And daughter of the predeceased, son of the predeceased daughter. Son of the predeceased daughter. So if these two people are present, then in the same way, these two people were getting the shares. The same way, these people will also be receiving the shares. So what I've tried to make you understand here is that all these people whomso have been mentioned under class 1 hires will be getting equal shares according to their line of inheritance. So for example, there is one person X who had immediately after his demise, he had son and daughter. So these two people will get equal share. And mother will get equal share. If the line of inheritance crosses forward, then if this person has died and there is a son and a daughter and a wife present, then whatsoever this person would have received if he would have been alive, that will devolve between these three people again. In the same way, X's property was getting divided into his son, daughter and mother and widow. Same way, his property that he has received, if he has survived X before his death, X's death, S died, then these people will also have received the property. But if after the death of X, S is there, then these people will not get the property. These people will not get the property of S. Okay, so this is S who has survived, who is still alive. And he had a son, he had a daughter and a wife. So that property will only be given to S and D and mother and wife. these people will not get the property until unless he has died before the death of X. That is why it has been mentioned predeceased. Predeceased. It means that during the survival of the person about whose property we are referring to, he had a son who died, and during the lifetime of that person, and from that son, the son who has died, he had a daughter, a son, and a widow. All these three people will get equal shares out of the share that the son would have got if he had been alive. In this particular case, this 33% share, if we talk about 1, 2, and 3 people, mother, let's take example wife, and then there is a mother also. If mother would have died before X, mother would have not survived before X, then the property would have been divided among these 3 people. So we will have to check through class 1 higher table that if there is a son, daughter, widow, mother, son of a predeceased son, daughter of a predeceased son, son of a predeceased daughter, daughter of a predeceased daughter, widow of a predeceased son, and son of a predeceased son of a predeceased son. Now, let's take the example. After this, there is one again son, again daughter, and he had a wife. Okay. So whether this property will go to the wife or not, the answer is no. Because the property will be divided to son, that is his son's son. This is X's son's son. To this particular point of time, you will get the property in the name of son, but not to the widow and to the daughter also. So this is how class 1 hires are actually providing the list of the people who will be given preference whenever the person dies without providing any sort of will. And now, after making you understand that, okay, this is exactly, this is how the property shall be divided according to the basis of the schedule, we first has to understand that what exactly are the definitions that has been mentioned under the Hindu Succession Act. Okay, the application we have already studied. Now let's try to understand the definitions here. Definitions and interpretation. The first definition under this act, the Act of Hindu Succession Act of 1956. What does agnate means? Agnate means one person is said to be an agnate. Okay, what is an agnate? Of another, if the two are related by blood or adoption wholly through males. Okay, so there is a person, let's take the example O. O had one wife with the name of W1 and another wife with the name of W2. And this happened before the codification of the Hindu Marriage Act. So this particular thing was there. He had one wife. Wife 1, from this wife, he had a son, S1. And from this wife, he had another son, S2. Now, if we talk about agnates, these two people, S1 and S2, will be called agnates of each other. Agnates of each other. The reason being, one person is said to be because if they are related by blood or adoption wholly through males. So now, this particular person, S1 and S2, will be considered as agnates of each other. Clear? Now, what is cognates? One person is said to be a cognate of another if they are related by blood or adoption, but not wholly through males. Now, cognate means there is one person X who married a wife. After the demise, when X and W married, they had a son. Then X died. Then the wife remarried with Y. From these couple, they had another daughter. So now these two people, the son and the daughter of wife W, will be considered to be cognates of each other. So this is what we need to understand in regards to what is agnates and what is cognates. Now, customs we have already studied, so we won't be indulging deep into it. And then what is full blood and half blood? We have already studied. Two persons are said to be related from each other by full blood when they are distant descendants from a common ancestors by the same wife. And by half blood when they are descendants from a common ancestors but by different wives. So if they are, this is full blood. Okay, so one person, same wife, they are blood relations. X, Y, get married, and after marriage, they had a son and a daughter. When the ancestors have the same wife, common ancestors, the common ancestor X is the common ancestor of X and D, and he had a one wife with the name of Y. So, wife is same. The mother of S is same for D also. So, daughter and son both will be called as full blood. These are full blood. And if they are descendants from a common sisters but by different wives. Now, this person X married with Y and had a son. And then after a certain period of time, X, after the demise of Y, married another person Z, and from them he had another son. So now these two people will be considered as half-bloods. Okay. So this is known as half-bloods. Two persons are said to be related to each other by uterine blood when they are descendants from the common ancestors but by different husband. Okay. So now take an example Y, who has happened to be a wife. She married a person A. Okay. And after the marriage, they had a son. After the demise of husband A, Y again remarries and she had husband B. From that, she had a daughter. Now these two people will be called uterine blood relation because they share perhaps the common ancestress. In both the scenarios, the wife is the same, but the husband is different. So that is why this son and this daughter is considered to be related in uterine blood. In this class, ancestor includes father and ancestors includes the mother. Then what does higher means? Any person, male or female, who is entitled to succeed to the property of an intestate under this act. Who is entitled to succeed to the property of an intestate under this act. What does now intestate means? A person is deemed to die intestate in respect of a property of which he or she has not made a testimonial deposition capable of taking effect. Okay. Now, let's try to understand that what exactly do we understand here by this is actually not relevant to you. This devolution of interest in coparcenary property. Okay, so the property of a person, of the coparcener means a person who are related to each other. By birth became a coparcener in her own right, the same manner as the son. Okay, have the same rights in a coparcenary property as she would have had if she had been a son. So both the son and the daughter has the right to the property. Be subject to the same liabilities in respect of the said coparcenary property as that of a son, and any reference to Hindu Mitakshara coparcener shall be deemed to include a reference to the daughter of the coparcener. Okay. So this is perhaps the most important portions that we are going to deal in regards to your section 5. That is much more, not of that importance for you either. But the most important portion that we should be studying here is section 8. What is section 8? Section 8, general rules of succession in case of males. So it says that devolution of male property dying in this state according to the provision of this chapter. That is, this is the first chapter. Firstly, upon the highest being the relative specified in class 1 of the schedule. We've just seen the class of the schedule. Then, secondly, if there is no hires of class 1, then upon the hires being relative specified in class 2 of the schedule. Okay. Thirdly, if there is no hire of any of those two classes, then upon the agnates of the deceased. Agnates we have just studied that if there is a person who has married, who's been related by a common ancestor, then he is known as agnates. And if there is a common ancestress, it is known as cognates. If there is no agnate, then upon the cognates of the deceased. Upon the cognates of the deceased. Order of succession among the hires in the schedule. So, among the hires specified in schedule 1, those in class 1 shall take simultaneously and to the exclusion of all other hires. Those in the first entry in class 2 shall be preferred to those in the second entry. Those in the second entry shall be preferred to those in the third entry, and so on in the succession. So if we talk about the order of succession, it is like this. This is class 1. If class 1, any of the person in class 1 is present, then all the rest people will be ignored. Okay. Let's take the example now that class 1 is not present. Then it will be devolved to class 2 hires. Okay. This is class 2 hires. Then, if these people are not present, then it will move to the agnates. If they are not present, then it will go to the cognates. And if the cognates are not present, then what? If the cognates are also not present, then the property shall devolve to the government, which is known as escheat. So this is the order of succession. When you talk about the Hindu Succession Act, we have numerous people or relative will be mentioned class 1. If any of them is present, this will not allow the class 2 agnates cognates to claim that particular property. So this is how we need to understand that the order of succession is perhaps very important for your CLAT examination. Order of succession has been asked that these are the people who are under class 1 and these are the people who are under class 2. Now, who will be given the preference in the property? Okay. So for you people, you need not get involved into agnates and cognates. All you need to do is you need to study class 1, who all are present under class 1 higher. That is son. Let's take like this. There's son, daughter, widow, then mother, then son of a predeceased son, then daughter of a predeceased son, then you have daughter's son, that is daughter of a predeceased son of a predeceased daughter, then daughter of a predeceased daughter, then you have a widow of a predeceased son, then you have predeceased sons, then you have son's daughter, then you have daughter's son, and you have daughter's son. So these are the people who are actually under class 1 highest. You have already known the schedule. I've just discussed the schedule for you. So you can just go through it because it is obviously will be getting confusion for you that so there are lots of sons and daughters going on. I understand it, but this is how you need to understand in regards to the Succession Act, because Succession Act is a little bit confusing. It is something a little bit complicated, but once you actually tackle it, once you try to understand it, it becomes very easier, because it is all you need to do is to create a family tree so that you can understand that what are the things and what are the preferences that has been given. Then distribution of property among hires in class 1 of the schedule. Now, how the property of an intestate shall be divided among class 1 hires in accordance with the following rules. What is the rule? The intestate's widow, or if there is any more widows than one, all the widows together shall take one share. This is X. He had one widow, that is wife. So if she dies, she will take one share. The surviving sons and daughters and the mothers shall take one share each. So there is one son, there is one mother, and there is one daughter. So everyone will take one share. So if there is one person X, he will be providing, if he has 100, the property cost is rupees 100. Okay, let's take the example that this 100 rupees will be divided into 1, 2, 3, 4. 4 people, and everybody will be getting equal share, because that is what has been mentioned here. Rule number 3. What does that rule number 3 get? The heirs in the branch of each predeceased son or each predeceased daughter of the intestate shall take between them one share. Now, the heirs of a branch of each, okay, heirs, this is X, this is son, this is daughter. Okay. Now it is saying the heirs in the branch of each predeceased son or predeceased daughter. Now this is son has died and this is daughter has died. And now they have son, they have sons and son's daughter. This is daughter's son and daughter's daughter. Now, if both of them has died, they will have one share and these two combined will have one share. Okay. The distribution of the share referred to in Rule 3, among the heirs in the branch of the predeceased son shall be so made that his widow together and the surviving sons and daughter get equal portion, and the branch of his predeceased son gets the same portion. Okay. So the things that I have just informed you when we were discussing about the schedule, these are the rules that has been mentioned there itself. Among the heirs in the branch of the predeceased daughter shall be so made that the surviving sons and the surviving daughter get equal portions. So out of one share, equal shares will be allotted to the son and the equal shares will be allotted to the daughters also. Okay. So this is how the property needs to be divided whenever there is a distribution of share of a person who has died intestate. And it becomes very important for you to understand these rules, because these rules are those things which are going to be asked in your CLAT examination. That these are the number of survivors. Okay, there is one husband, there is one mother, there is one daughter, there is a daughter's daughter, and they have died. Now, to whom that property will be given, what amount of share that will be received, and that is what has been mentioned under the section 8 and the section 9 and section 10, which talks about the rules and the succession and the series. Okay. So distribution of property in regards to class 1 higher is clear. We have understood that once if any of the predeceased sons inheritance is there, the widow, the son and the daughter will be getting equal portion. After the line of, if the predeceased son is there, if the son has died, then the surviving sons and daughters will get equal shares. And if the branch of his predeceased sons gets the same portion also. The distribution of property among heirs of class 2 of the schedule. Now we have understood class 1. Now we are moving forward with class 2. The property of an intestate shall be divided between the heirs specified in class 1 entry in class 2, and so that they get equal share. Okay. This is ignates and cognates. That is not important for you. And then we will be studying about the property of female Hindu. But that is something that we will be discussing obviously in our next class, because today's class was a little bit hectic. You people might have also been, a lot of confusion would have been there, that sir is talking about sons and daughters and sons. But I understand. It is sometimes we get topics which are very easy to understand. Sometimes there are a little bit complicated topics are there. But what we need to do is we need to create a tree. Once you start pictorial representation of the diagrams and see to it that, okay, this is the surviving member, that is not the surviving member, who will get what share. Once you understand it, once you are able to clear your ideas and understand that whom will be getting what share, it will be very easier for you to figure out that if somebody has died without leaving any will, then to whom his property will be given. Okay. Taking that thing into consideration, I would request you all to kindly go through schedule 1 at least once and try to make a pictorial representation by yourself that what exactly it is talking about. And here, if in schedule 1, if there is any person who has survived, then even if one person has survived, what it will do is it will nullify the succession for class 2 highest ignates, cognates and any other person. If class 1, the whole amount of relatives who have been mentioned at class 1 highest is not present, then it will be given to class 2. If class 2 is also not present in class 3, and then class 3 is not also present in class 4. All you need to do is you need to remember the names of the persons who have been mentioned in class 1, and that will be much more helpful for you in order to clear the examination of your CLAT syllabus. Okay, CLAT, in order to clear the CLAT examination, and that particularly in regards to the Succession Act, the questions will be pretty much easier for you. In our upcoming video, we will be discussing about the property of female Hindu. If she has occupied, it will be an absolute property, and then we'll study that how the property which consists of a Hindu female, how will it be divided among her successors. So I would again request you all to kindly go through this provisions again, that what we have discussed in this current lecture series, and then we try to summarize and we'll try to figure out how the female has been given authority to segregate their property if they dies without leaving any will. With this, I would like to thank you all for being present here. I wish you a very best of luck that in the coming lectures and in the coming examinations, you will be able to get a clear idea and clear the examination. And so far, I am satisfied and I'm confident that once we are able to complete the whole syllabus and you are able to grasp the principles and you apply those principles in your examination, in your mock test series, in your previous year question papers, and you try to practice it, nobody can stop you from clear this examination. With this motivation, I would like to thank you all again. Bye-bye. Take care.